My name is Stephanie Hill, and I wanted to welcome you to our webinar about changes in the Brown Act from 3 of Governor Newsom's recent executive orders relating to the COVID-19 pandemic. Everyone here at Myers-Nave would like to express our deepest concern and support for the health and safety of all the clients and communities that we serve. A few things to get us started. For presenting purposes and to eliminate background noise, the audio function of this webinar has been muted for our guests. If you have any questions during the webinar, please submit them using the Q&A button located in the black bar on the top or bottom of your screen. Our presenters will do their best to answer all questions at the conclusion of the webinar. We are offering MCLE credit, and those certificates will be emailed to you by the end of this week. Another note, given the high participation traffic that webinar systems are currently experiencing, we circulated a copy of the PowerPoint PDF this morning. If we experience any delays in advancing the slides during this live webinar, we will let you know the slide number that is being covered at that time. Today's presenters are Eric Kasher and Richard Pierota. Together, they have over 30 years of experience in public agency law. Eric and Rich are principals in Myers-Nave's Municipal and Special District Practice Group, and Eric chairs the practice. They serve as city attorney for cities of all sizes and general counsel for special districts of all types throughout California. Eric and Rich advise on the regulatory, transaction, and litigation issues that public entities face as they implement their mandates and missions. Eric and Rich, thank you guys for your time today. I know we are all looking forward to hearing your thoughts and advice on today's topic. The floor is yours.
Great. So this is Eric Kasher. I want to welcome everyone to our webinar this afternoon. And thank you, Stephanie, for that introduction. I'm glad that everyone is able to join us this afternoon. And let's go ahead and get started with the material. So just by way of introduction for the presentation, by now, many of you have seen the various executive orders from the governor in response to this COVID-19 pandemic. You know, he's covered a range of issues from declaring a state of emergency, ordering a shelter in place, restrictions on residential evictions, but most notably for us, and for what we'll be focusing on today, is the governor's executive orders that have impacted the Brown Act and our ability to conduct public meetings. Our goal for this presentation is to provide you with an overview of these executive orders, what they mean, how they impact your ability to conduct public meetings and the Brown Act more broadly, and most importantly, provide you with some best practices and suggestions on how many public agencies throughout the state are dealing with these changes and conducting electronic meetings for the first time for many of us. As Stephanie mentioned, I am the chair of Myers-Nave's Public Law Group, and collectively we serve as the city attorney for 17 different cities throughout the state of California, and general counsel for another 25 to 30 special districts. And so we've pulled together what we consider to be many of the kind of best practices from a lot of the various agencies that we represent. We hope that you'll find what we have to offer here helpful in that regard. I do want to note up front that there isn't a one-size-fits-all approach to handling electronic meetings and really applying some of these executive orders, but we're going to give you guys a sense of some best practices and some different tips that you can take away. So hopefully you could have a little less anxiety about maybe conducting your first electronic meeting, and you'll have some good guideposts in which to guide you moving forward. So the agenda for the meeting is up here on the PowerPoint. I'm going to start off with just a brief high-level overview of the Brown Act, in particular focusing on those sections of the Brown Act that have been impacted and or changed by this executive order, the executive orders by the governor. And then we're going to focus on the details. So the 2 executive orders, N-29-20, keep in mind this supersedes the March 12th order, and this is really the order that gives us the guidance on how to conduct public meetings and electronic public meetings. And then finally, we'll also talk about N-35-20, which is the most recent executive order impacting the Brown Act, in particular, the ability to have meetings where our councils and or boards are receiving briefings on that are relevant to the COVID-19 pandemic. And finally, we're going to answer questions that you have and hopefully have a little bit of a robust Q&A discussion and talk more about the practical aspects of these items. So next slide. Great. So everyone here is very familiar with the Brown Act. I wanted to just provide this very high-level overview. The government code sections that have been impacted by the governor's executive orders can be found at Government Code Section 54950 and follows. Those are the requirements of the Brown Act. There has been comments, and oftentimes by maybe members of the private sector who have to interface with government, saying, well, the Brown Act has been suspended, and somehow maybe think that the Brown Act no longer applies. It very much does. There are certain sections of the Brown Act that there have been exceptions created for this executive order, these executive orders, and that's what we're going to cover today. I also wanted to mention our partners and colleagues at the League of California Cities. They have done a really great job in publishing an overview of the Brown Act, a copy of which, just the image is included here. So for more of a higher level overview of the Brown Act, you can certainly consult that source for more information. Next slide. Great. So the Brown Act, and everybody's, again, very familiar with it. It was adopted in 1954. And there is, we won't go into too much detail about the specifics of the Brown Act, but what we are going to be focusing on primarily is the requirements around public meetings, in particular, meetings of legislative bodies, and this requirement that those meetings be open and public. Next slide. Actually, before I get to this, there's one thing I want to mention. There's a number of sections of the Brown Act that have been amended since 1954, and there's one provision that has remained unchanged, and that is the section that reads that all meetings of legislative body of a local agency shall be open and public, and all persons shall be permitted to attend any meeting of the legislative body of that local agency with limited exceptions. And so ultimately that's our charge. We want to be able to be as inclusive. We want our public meetings to be as accessible as they can be, given the state of affairs that we're in and in these new executive orders. And how do we do that? How do we create access for members of the public who maybe don't have the means to attend electronic meetings? And so that's really our charge, and that's what we're going to be talking about a little bit today. So overview, legislative bodies. So a Brown Act body, when we talk about these exceptions to meetings, a Brown Act body is a governing body. So we're talking about your city council, your commission of a JPA, maybe your board of directors for a special district, an appointed body, an example being a planning commission of a local city, and then also a standing committee. I'll talk a little bit about the distinction between standing and ad hoc. A standing committee is your finance committee in your city, for example, that meets regularly. It meets every month to discuss the finances and the budget and things like that. This does not apply to, and the Brown Act does not apply to, ad hoc subcommittees. So an ad hoc subcommittee is a committee of your council, for example, that is convened for a very limited purpose, a specific purpose for a limited time. The Brown Act does not apply to those ad hoc subcommittees. Next slide. Okay, so again, these executive orders relate to and explicitly reference the new requirements around meetings. So we want to make sure we're all on the same page regarding what is defined, how the Brown Act defines meetings. So a meeting is a congregation of a majority of the members of your legislative body at the same time and place to hear, discuss, or deliberate on an item of business within the agency's subject matter jurisdiction. So that is what a meeting is. We're very familiar with our traditional meetings, our city council meetings, our commission meetings, our planning commission meetings. There are exceptions that we're very familiar with under the Brown Act for conferences. If you have members of your legislative body who are all attending a conference or a community meeting, social or ceremonial occasions, there is no prohibition under the Brown Act for individual contacts between council members, but I'll talk a little bit after this about serial meetings, mention standing committees and ad hoc committees, and then meetings of other legislative bodies. So if your entire city council decides to attend the school board meeting to speak as, in their private capacity as residents, they can do so, and that's not a meeting under the Brown Act. Next slide. Okay, serial meetings. So this is a rule, and there's some exceptions that the new executive orders have changed related to this, but the general rule is that a majority of your legislative body may not, outside of a meeting, use a series of communications to discuss, deliberate, or take action on any item of business. So that's the general rule under the Brown Act. We're going to see, and we'll speak to some of the exceptions related to this in particular as it relates to receiving updates on from your city manager or your general manager regarding your agency's response to the COVID-19 epidemic. So we'll touch on that. Next slide. But this is an exception. It does not prevent employees and or officials from engaging in separate conversations outside of a meeting, provided that the comments or positions of the other officials are not communicated. So employees can talk to your council members. Obviously, your department heads may and likely do. That's not a violation of the Brown Act. We'll talk more about this in the next slide. Okay, closed sessions. So closed sessions are essentially a meeting of your legislative body conducted in private without the attendance of the public or press. And the legislative body is authorized to meet in closed session only to the extent expressly authorized by the Brown Act, and there are very limited exceptions for that. So we've listed those exceptions here, discussion of real property negotiations, pending and threatened litigation, the initiation of litigation, personnel matters, labor negotiations, and public security, safety issues. This is important because the new executive orders create some very interesting practical and logistical considerations about how do you actually conduct a closed session when you have a public meeting that may, for example, be over the Zoom platform or a video conference. How do you open a meeting to take those initial public comments and then close the public meeting to convene into closed session? Then you reopen and report out. So there's some logistical challenges to that, but here's the requirement, and we'll talk a little bit later on about how to get around some of those kind of logistical hurdles. Next slide. Okay, posting requirement. So we're all familiar with the posting requirement, and this is really important because these new executive orders create some new requirements around what needs to be included in your agendas. So when you post your agenda for your regular meeting, which needs to be posted 72 hours before, there's some new language that you're going to want to include, some new disclosures and information that will need to be included in those regular meeting agendas before posting. So you have your regular meeting agenda. The Brown Act still allows, and these executive orders still allow for special meetings. Those special meetings, the agenda must be posted 24 hours in advance of that meeting. And then I also wanted to speak in particular about these two exceptions. One is for an emergency. So the Brown Act and these executive orders still allow for a public agency to convene a meeting of the legislative body for an emergency purpose. So this may be a situation where 9 o'clock in the morning, city manager gets a call, a directive perhaps from the county or maybe even the governor saying that a public facility needs to be used for a specific purpose for, let's say, in response to the COVID-19 pandemic. The city manager and the council don't have enough time to convene a special meeting within 24 hours notice. So they could convene an emergency meeting within the same day, at 5 o'clock that day. There needs to be an actual emergency. If there are news media that are typically notified of the public meetings, they would need to be notified within an hour in advance of the emergency meeting. But there is still that flexibility that exists under the Brown Act. So I wanted to just remind folks that that is out there, and that's something that can still be done because that's something that some of our agencies may be looking to do given the times that we're in. And then finally, urgency items. So there is still the ability to bring an urgency agenda item. This is a situation where you've already posted your city council meeting agenda that will take place 72 hours later. And there's something that comes up that you want to have discussed at that city council meeting. It's not on the agenda, and as we know, you can't discuss items that have not been agendized and that are not on the agenda. There can be the addition of an urgency item for discussion and direction to be handed out at the meeting, but you need a 2/3 vote of your legislative body. So if that's a 5-member city council, you need 4 members of your city council to vote in favor of hearing that urgency item, and then you can move it forward. If it's a 7-member board or commission, then you need 5 of your members. So just wanted to mention those 2 items because those are still available to you as public agencies under the Brown Act, and it's inconsistent with the governor's orders. So next slide. Okay, public participation rights. So this is really kind of the crux of what we're dealing with these new executive orders. Regular meetings must provide an opportunity for the public to speak regarding any matter within the body's jurisdiction. So we're all familiar with our public meetings and having an agenda item to allow for public comment. How do we do that now with electronic meetings? If we're in a video conference or a conference call, how do we allow for public comment? The Brown Act also allows for members of the public to address the legislative body on matters that are on the agenda before they're considered. So typically you'd have an item brought forward, a staff report, a staff presentation, and there would be an opportunity for the public to comment on that agenda item. How do you do that now with this kind of new normal that we're in? So we're going to talk a little bit about that, but I wanted to lay out that framework and requirement that still exists, because ultimately we're still trying to meet the spirit of the Brown Act, but there's some challenges now, and we have to figure out how to do that and create this open, public, and accessible forum given the restrictions that we now have. Next slide. Okay, so at this point, Rich is going to take over and talk a little bit about the teleconference meeting requirements, and then we're going to get into the nuts and bolts of these 2 executive orders from the governor. So take it away.
Thank you, Eric. Good afternoon, everyone. This is Richard P. Arota. I'm also a partner at Myers-Nave, along with Eric, in the public law group. And carrying on the presentation from here, as we all know, these are the rules for teleconference meetings. If you don't know, now you know that you're allowed to do a teleconference meeting under the Brown Act, Government Code Section 54953. And the teleconference is defined as a meeting of the body where the members of which are in different locations connected by electronic means through either audio or video or both. And they may be used, teleconferencing may be used at the governing body's discretion. That's what's in the Brown Act right now. Meetings must comply with all otherwise applicable provisions of the Brown Act. So this is all good preface to say that the governor's orders changed this section in a fundamental way, as we'll explain in the later slides. But this is the basic rule right now regarding teleconference meetings under the Brown Act. Next slide. So we know that teleconferencing can be used for all purposes during any meeting. That was before the orders went into effect, and that is current after the orders have gone into effect. At least a quorum before the orders went into effect under the teleconference rules, at least a quorum of the body must participate from locations within the jurisdiction. That's the current rule. Additional teleconference locations may be made available for the public, and each location, such that they may be put into effect, must be specifically identified in the notice and agenda for that meeting, including full address and room number as applicable. Next slide, please. So, as we know, each teleconference location, including a hotel room or residence where our legislative body members may be, must be accessible to the public and have technology such as a speakerphone to enable the public to participate. Yes, we know that when our members, our legislative body members, were perhaps traveling and they were at a hotel, they were using either their hotel room or the business center at the hotel, or perhaps their own home. But those locations had to be accessible to the public, which meant they had to be ADA accessible. The agendas for those meetings where a teleconference was occurring, where the teleconference location, let's say the hotel or even the residence of our legislative body members, they had to be posted at each teleconference location. So the agenda for the meeting had to be posted at the hotels, perhaps outside the hotels, right on the hotel sliding door, or just outside of the business center, even if that location, of course, was a hotel room or a residence. And the agenda had to provide the opportunity for the public to address the legislative body directly at each teleconference location. And we had those announcements perhaps in our teleconference agendas. And we knew that all votes must be by roll call vote. So those are the rules under 54953 of the Government Code related to teleconference meetings, again, under the Brown Act. Next slide. Well, now we have the new executive orders. So what do the new executive orders do? We know that, here's a summary of the changes, and right now we need to follow paragraph 3 of the executive order N29-20, which was issued on March 17th. For those who are practitioners, those who are curious, it's important, I think, to read paragraph 11 of the executive order N25-20, which came out March 12th, for background regarding the N29-20 order, which is the one that's currently in effect. So if you're looking for the orders, look for N29-20. If you're curious and want to get some more information about where the governor initially went to and why we got to N29-20, definitely read N25-20. These are all accessible on the governor's website. If you just type them into Google, they're easily accessible and brought up. Most of the Brown Act's teleconference rules under these orders, those teleconference rules or requirements are waived or suspended. Public meetings then must be accessible telephonically or otherwise electronically. And a combination of video conference and teleconference is allowed. Clearly, this is all in response to the need for us to be socially distancing ourselves from each other, including the members of the legislative body. So the governor has determined it's not enough that we have enough space on the days between individual members, or that a mix of members can be in the meeting with staff while others are teleconferenced out, or that the members of the public may be allowed to sit in our chambers. We know, and I think this is in response to that the governor is reacting to the amount of difference between public agencies' facilities and the ability for social distancing to happen, which is, I think, the primary driver for why N29-20 was passed, is to obviously push us when we're doing the public's business to be as socially distanced as possible. Next slide, please. A physical meeting location for attendance by members of the public and our staff, for that matter, and for offering public comment is not required. When you'll read the two orders, N25-20 and N29-20, you'll see N25, the March 12th order, had a requirement that there had to be a physical location for members of the public to come and participate in the meeting and provide public comment. So in response to that, some of our clients were opening up their city council chambers, even though all of the members of the legislative body didn't have to be there. They could participate by teleconference. It created an interesting situation of members of the public speaking in an empty room, essentially. That is not a requirement under the new and currently in effect executive order. There's no requirement, like there usually is under 54953, the teleconference rules, for a quorum of the legislative body's members to be within your public agency's jurisdiction for a legally compliant teleconference meeting under the Brown Act. So that means that our members, your legislative body members, could be in disparate locations, completely out of the country possibly, let's hope not, but perhaps out of the county. Perhaps they're with their loved ones in a different county taking care of those who are in need. Well, then absolutely they can still be and participate in the legislative body's meetings outside of the jurisdiction through these new rules. And it's important to point out that right now the orders only apply, and this is explicit in the executive order, the orders only apply when state or local public health official imposed or recommended social distancing measures are in effect. We are, I believe, reading this to say that once the orders are lifted by the state or local public health official, then the Brown Act will revert back to the regular teleconference rules, and we'll just be back to business as usual. Next question, please. Next slide. During teleconference meetings, again, at least a quorum of the members of the legislative body are not required to participate within the jurisdiction from locations within the boundaries of the territory. And this is, again, I'm reemphasizing this. It's important to say that because it allows our members to not, it doesn't require a quorum to actually be in the jurisdiction to hold the meeting, to call the meeting, for any action or discussion to happen. It can all now occur over teleconference or video conference. And the notices and agendas are not required of each member's teleconference location, which means that we don't have to post on the members' residence, assuming that they're residents, that there's an agenda and a notice for a public meeting occurring at that. Again, wanting to maintain social distancing and not require the legislative body member to open their home to members of the public who want to make public comment. It just seems absurd during these times, but needs to be said, it's explicit, that we don't have to require the residences or wherever our members are teleconferencing into the public meetings, that they be public and open. Next slide, please. So what I was saying, each teleconference location explicitly is stating does not have to be accessible to the public. You don't have to open your home to the public to allow them to come in and listen in on the meeting and provide public comment. And public comment, again, is not required at each teleconference location. And I want to emphasize the point again, the public agency does not have to open a room at a community center, a room at the city hall. It's chambers open to the public. Perhaps your facilities are closed. Perhaps your city hall is closed. That then they would be required to have that open during this time. That is not a requirement under the orders. And the agendas, again, do not have to be posted at all teleconference locations. Next slide, please. The orders are explicit about notice and accessibility requirements, though. So the orders say you must have and advertise a procedure for receiving and swiftly resolving. So we have to have a procedure for receiving first, and a procedure or a statement about swiftly resolving requests for a reasonable accommodation from individuals with disabilities consistent with the ADA. This is not different from what's currently in the Brown Act, but we want to point out the orders are explicit about this. And I'll get into that a little bit more when we have some examples later on in the presentation. We need to provide advance notice of the time of and post the agenda for each public meeting. Where would you do that? We believe you're doing it on the website. So you're doing it on your public agency website. It's possible, I presume, that it doesn't say that you can't, but that your clerks or administrative staff are posting it on the bulletin boards outside of your public facilities, your city hall, or your main office, your main facility. You still have to do that, but we believe that posting it just on the Brown Act, posting it just on the website is compliant with the orders at this time, especially if your facilities are closed or they're under some sort of lockdown. But you still have to do it according to the timeframes that Eric mentioned as prescribed by the Brown Act, which is 72 hours before a regular meeting. For any other meeting that's not a regular meeting, then it would be a special meeting notice, which would be 24 hours. Now, if you're having a regular meeting of one of your standing committees, then it's still 72 hours before a regular meeting of that standing committee. But if you're having a special meeting, then you would have a 24-hour notice period. What we're finding, just an ad hoc observation, is that most are providing as much notice as possible, greater than 72 hours, which of course is allowed by the Brown Act. The 72 hours is a minimum. And you have to include the means by which members of the public may observe the meeting and offer public comment. We'll provide examples of that. So what does that mean? Practically speaking, is providing the Zoom, for example, if you're using Zoom as your platform, your application is providing the location for the Zoom meeting, the HTTPS signature. You also may be providing the telephone numbers, both a local telephone number or a toll-free number if one's available, and we'll provide examples of that in the later slides. Next slide, please. So here's an example for the additional information for meeting notices that Eric mentioned earlier that we're seeing and we believe is legally compliant, is that you provide this particular example in the agenda in some way, typically maybe on the face page or up just below the title of your agency, whatever information, the letterhead, if you will, you would have in bold this information below the information about the time and place for the meeting. The time and place being the video conference location, the video conference address, if you will. Perhaps the teleconference number. You'd have this information up there. For those who don't see the presentation, I'll read it briefly, is that this meeting is being held in accordance with the Brown Act, as currently in effect under the State Emergency Services Act, the Governor's Emergency Declaration related to COVID-19, and the Governor's Executive Order N29-20 issued on March 17, 2020, that allows attendance by members of the City Council, city staff, and the public to participate and conduct the meeting by teleconference, video conference, or both. This provides you the cover under the Brown Act now to hold your meeting as a teleconference meeting, and putting that statement out there. Next slide, please. Here's an example of the noticing that you need to provide related to using one of the platforms. If you're using GoToMeeting, you'd provide the HTTPS address for that meeting. But here we're using a Zoom meeting. This is just an example. These are just the fake numbers. But clearly, you're going to have information about the Zoom location for that meeting. You're going to provide a phone and dial-in number if you're going to be doing it. Also, if you're going to providing, if people are going to be participating by phone because they don't have access to Zoom, or they don't have access to a computer at that time. And then, of course, we've been advising to use international numbers sometimes for those, if an international number may be available, contact the city clerk so that someone may ask to see if they participate if they're in an international location. Next slide, please. As far as accessibility, we've been seeing this as well, and this is probably not much different from what's in your agendas already. But this is from a special district that they're requesting individuals who require special accommodations to access and/or participate in district board meetings to contact the district office. In this case, at least 3 business days. It depends on the agency, but providing a reasonable amount of time is what we recommend. And this is, again, in your 72 hours notice. We recommend posting this on your website, if possible, as well, as a general statement, so that it's completely out there and the information's available that your district is complying with the ADA and the Brown Act by providing those who require reasonable accommodation the ability to participate in the meeting with some advanced planning in coordination with your staff. Next slide, please. We've been also checking to make sure that you want to make sure your public agency's website is ADA accessible. We know that a lot of agencies are doing that now in their IT departments. If you are not, or have not thought about it, it's a good time to start thinking about it. Also, as to whether your staff reports and your attachments to staff reports are ADA compliant. If you're using a provider such as a Granicus, for example, is a good example. They provide the accessibility standards that are available, as well as Adobe. When you're using PDF documents, will they be able to be, are they compatible with a reader? So you want to be able to, you want to check those particular requirements on your website. And if it's with one of your agenda management platform or providers, check with them as well. Most of them already do, but it's good to double check, especially at this time. Finally, this last bullet point, under the order, the Brown Act emergency notice is permitted, and that you can alert the media to telephone and video conference only meetings by your website, by just using your website. You don't have to notify them, you don't have to call them if they're on a list. It's always a good idea to, but we know that some agencies, or maybe your agency, maintains a list of interested parties who want notice of Brown Act meetings every single time. They want it by fax, they want it maybe hard copy, and you don't have that capability right now because staff's not in the offices. You can do it by website only, and that's specifically allowed and complies with Government Code Section 54954E under the Brown Act emergency notice requirements. So notifying those who want the consistent paper updates or paper agendas, or they want them by fax, you can do it just by website only for now under the orders. Next slide. I do see, before I hand it off to Eric on this particular executive order, thank you for your questions. We'll be answering your questions. We are almost done with the presentation and plenty of time. We're about 30 minutes in, just a little over 30 minutes. So we'll be taking questions through the Q&A part of the application here, and we'll be answering them live. We'll be reading them and answering them live as we go through the presentation. So I'll hand it back to Eric. Thank you.
Great. Thank you, Rich, and thank you for covering some of those more detailed slides here with the requirements. So let's talk a little bit about Executive Order N35-20. So this is the most recent executive order from the governor that impacts the Brown Act. In particular, this is the change that relates to the briefing of our legislative body related to updates concerning the impacts of COVID-19 in the government's response and aspects of that. So under this executive order, this allows for serial or simultaneous updates about matters that are relevant to this COVID-19 pandemic. It allows members of the legislative body to ask questions during the update, and it also allows those updates to occur without the public's access or attendance. So this can be a city manager or general manager convening a conference call to brief the city council and or board regarding the city or agency's response to a new directive from the governor. That's the type of example we're talking about. It could be a city manager or general manager talking, convening a conference call to talk only to the legislative body about some of the things that the agency plans to do moving forward to deal with what might be a May 1st date for this, the end of the shelter in place. So that's what we're talking about here. That would not be a violation of the Brown Act. Those are permissible updates that can occur under this new executive order. Next slide. So a couple of things to note of importance. So here's what's allowed under 35-20. Members may ask questions of the federal, state, and or local officials who provide the updates in order to stay apprised of emergency operations and the impact the emergency has on constituents. But what's not allowed is that members may not take action on or discuss amongst themselves the subject of the briefing. So any item of business that is within the subject matter jurisdiction, you can't make it take action or discuss that on the call. Otherwise, you could run afoul of both this executive order and the Brown Act. Next slide. Here's why this particular executive order is a little bit tricky, because the language of the order explicitly states and provides that the legislative body may receive updates and they may ask questions, but they may not discuss amongst themselves or take action. So so one of the practice points is if you feel like the subject matter of the briefing or the question that's being posed would create some level of discussion, that's really something that maybe should be agendized for a special meeting 24 hours later, or maybe agendize it for a future regularly scheduled council meeting. But the legislative body is not allowed to discuss and or take action. So just an example of this, one recommendation would be these updates are really meant to be informative and to be instructive, and not to be a forum at which your legislative body can discuss whether or not you want to close down a certain public facility that might still be open, or whether or not they want to make a decision on a further declaration, or a declaration of a local emergency when one hasn't been issued yet. This is really for the legislative body to receive information from either federal, state, or local officials, and to ask questions, but not to have discussion. And so what I would recommend is that meeting really should be chaired by the local official, either a city manager, general manager, or someone at the staff level, not necessarily the mayor or the chair of the board. I think that's one thing that you can do to make sure that you're within the spirit and the requirements of this order. It's a briefing that's going to be provided to the legislative body, not a forum at which a discussion can take place. Next slide. Okay, so this is one that I'll just go ahead and lead the discussion on this, and Rich, I'm going to ask for you to feel free to chime in. I spoke a little bit earlier about this issue of a closed session and the challenges associated with just logistically with conducting a closed session in this new framework of video conferencing and teleconferencing. So both teleconferences and video conference platforms are permitted, and it may be a mixed format. And so here's an example of what we've seen some agencies doing that has been successful. There's definitely some kinks that need to be worked out, but one idea would be to open your public meeting before your closed session and take public comment via video conference. So this would be assuming that you're having a Zoom platform meeting similar to this webinar. And so the public meeting will be taking place on a video conference platform. After you open the public meeting, you ask for any public comment on the closed session agenda items, because you do need to allow for public comment on those closed session items. Once you've received public comment, the chair of the meeting can then convene a closed session. And in going into closed session, practically you would essentially pause the video conference, and maybe go to a teleconference only meeting. So you would then provide your legislative body with directions, a new dial-in number that they would then call in on their phone as opposed to using their computer, or maybe even a separate Zoom meeting ID and meeting that they would essentially join to conduct the closed session. And then upon conclusion of the closed session, they would then re-enter the open session in the video conference that the public is still in, and read out the action from the closed session, and then proceed with the remainder of the public meeting. I know that has been tried in some cities, and there was a little bit of, I think some of the feedback was that, it can take a little bit of time because not everybody is calling in right away, and there might be some delays. But that's one way to do this that I feel like it meets the spirit of the order, and it's logistically it can be pulled off and done well, and can be seamless if you provide some good directions to your legislative body up front and walk them through the process so that they can hopefully move through those requirements. Rich, did you have anything you wanted to add to that?
Yeah, just to point out that if you're going to be doing a mixed meeting, then you would want to do the video, be very clear about the public portion will be through the video conference. And you would notice that the meeting, let's say you're doing just a closed session meeting. So this is a special meeting, a closed session that's not part of your regular meeting. I understand the procedures could be used for both, but here for this particular example, this works, is that you have a special meeting agenda, you have a 24 hours, you're calling a closed session, and you notice that, of course, you have to open the meeting, it's a special meeting, you only have the closed session as the agenda items, but you open the meeting in open session because you have to allow the public opportunity to speak about any of the closed session items, sparse as that may be most times, but you have to provide that opportunity. So you would open the video conference, you would notice it as a video, you would notice the special meeting as a video conference. Then you would put a special, you would make an agenda disclosure, an additional disclosure that the City Council will meet in closed session by teleconference. Now we know that in that particular instance, you don't have to list the teleconference number because in their meeting in closed session, you're allowing the public the ability to participate in the meeting through the video conference format that Eric just mentioned. You don't have to list the teleconference number for just the closed session. And clients are liking the ability to just have a separate closed session teleconference without having to advertise the number. It's just proprietary to the members because clearly they don't want to have the mistake of dialing into a number where the public could be open, the public could be listening in inadvertently. So you want to provide a separate number that doesn't have to be advertised. And then if a closed session action is taken, or you want to announce that no closed session action was taken, but direction was provided to staff, you would reopen the meeting in the public session under the video conference and then adjourn the meeting. So that's just an example of a way you could procedurally do this and not get tripped up and inadvertently allow the public to be in your closed session or listen in. Next slide. We've come to the end of the presentation part of our webinar today. We have a number of questions we see here, and I'm going to, while Eric is taking a look at some of the questions that have been put in, we did have some questions that were submitted before the webinar that we'd like to get to. Again, these are from folks who signed up and registered for the webinar and submitted questions to us through the registration app. Do we need, one of the first questions, do we still need an ADA location? No, we do not. And then, but the teleconference systems, do we know whether they're confirmed as ADA compliant? We don't know, and we don't have any advice at this point in time, unless Eric does. I don't, as to whether any of the platforms that are out there for video conferencing are confirmed to be ADA compliant. But I do want to stress that websites and the staff reports and the attachments to your staff reports, to the extent that they're made available by your agency on the website, should and must be, in my opinion, ADA compliant through some sort of reader format. And Adobe, again, makes a great product for this. There are maybe others. Check with your agenda management provider or agenda management system to make sure that it's ADA compliant. Eric, do you have anything to add to that?
Yeah, the only thing I'd add is more of a suggestion, and this is something that I've been advising some of my clients, in particular city clerks, as part of your agenda that you are posting. And there's the disclaimers that we're now including regarding ADA and accessibility. I think one good idea would be to, if you're asking, for example, for members of the public to submit questions via email, and that's something that we'll touch on briefly, you might also include some language in there that says if for whatever reason the platforms that are being provided above, teleconference or video conference, are not an accessible means for you, please notify the city clerk and let us know, so essentially you could do your best to create an accommodation. There may be a situation, just given technology and the like, that there may not be the ability, just depending on what the accessibility barrier is. But it's just something that the city, that your agency can do to be proactive about identifying members of the public who may want to attend, who may be giving you a heads up in advance so that you could try to create something in advance of a meeting, just to have a little bit of a head time on that.
You know, going on that same thread, Eric, going to the questions that were received through the webinar, may the body require that all public comments be submitted in writing or by email by 5 p.m. the day before the meeting? And if so, should the agenda be posted at least 72 hours before the 5 p.m. comment deadline? Do you have I have thoughts about that. Why don't you go ahead?
Yeah, so I think that's a really good question, and I think that's one that many of us are struggling with. You know, we are recommending that people submit comments via email, and so when is the cutoff? You know, do we want to have a 5 p.m. the day before the meeting or the day of the meeting, and what's an appropriate time frame? I think the executive order is silent on that, but the executive order also says that we are to, you know, besides the exceptions that are provided, we are still somewhat required to maintain all other, you know, requirements under the Brown Act, and so create the most accessible means of communication you can. So I think you can certainly say we want to receive email comments by 5 o'clock the day of the meeting, and to set a time frame. There's this open question of, what if it's not just a public comment, but if it's a comment about an item on the agenda that someone wants to be able to ask in real time? And so I know some agencies have those capabilities where they're using a Zoom meeting platform. There's an administrator who's monitoring the meeting. The administrator is identifying the questions that are popping up in a queue. All of the microphones are muted. When the time comes for the comment to be read into the record, or essentially the microphone to be activated, they're allowing members of the public to speak that comment into the meeting, essentially through the Zoom platform. So there are some people who are agencies that are doing that. And I have also seen other agencies that are saying, nope, we're only receiving email comments and we'd like to have those by 4 o'clock the day of the meeting. I don't know that there's a bright line rule on what's acceptable or not. We obviously want to just be mindful of the fact that we want to avoid any challenges, Brown Act challenges here. And so obviously doing whatever you can to allow for as much public comment as possible. And if in real time, that's, if you have the ability to do that, that would obviously be best. But open your thoughts on that too, Rich.
I think if we are starting to go towards video conferencing and a teleconference meeting format, a video conference that allows members of the public to participate in the video conference or something like this does allow for the ability for the administrator to halt or mute individuals or participants and just have the panelists or the legislative body members be the ones who are able to speak and have the chair run the meeting in that fashion. We've got a similar question where individuals, this term called Zoom bombing, or someone that is jumping into a Zoom meeting and trying to take over the meeting by dominating the conversation or not being able to mute them. It's a relatively new phenomenon, we understand, but controls are in place, and the administrator, and you're allowed to make controls, I believe, under the orders, so that you can mute all attendees until the public comment portion of the agenda, so you can manage a good meeting, meeting that flows as well as you can as you do in public. When public comment is asked for, in this particular type of format, you can have participants raise their hands electronically if they wish to speak, or they can submit their questions and answers as a way to raise their hands. Then the administrator will take note, create an order for that particular agenda item, and then unmute the speaker and allow them to speak, or read their comment in to the record at that point. The Brown Act speaker rules apply, like we said, including the procedures or rules related to meeting disruption, or staying on the agenda topics, or staying within the subject matter of the jurisdiction. So even though First Amendment concerns are a priority, of course, at least for that public comment period, you can still use reasonable controls to allow members to participate by submitting their comments to the legislative body and then muting them. I think that's as much as possible what we should do when we're having video conference and teleconference meetings. I think I'm going to the next question here is that some associations are recommending that the agency adopt a declaration or resolution altering the regular meeting location due to a local emergency caused by the pandemic. Is it really necessary for the agency to adopt a reso if the agenda contains the disclosures we provided and the agency follows rules in the order? As we can point out, so normally resolutions are not necessary to simply comply with the meeting law. I think that's right. I think what we're seeing and we're providing is that as long as you are clear about how members of the public can participate in the agenda and the notice for the meeting, whether it's through Zoom and you provide the Zoom address or the teleconference location, you've complied with the Brown Act by making sure that information is in the posted agenda that you post on your website, and you may post at your facility, but posting on the website under these circumstances, under the orders, is completely in compliance with the Brown Act. I mean, just posting to the website is okay. So you don't have to, I think you don't have to adopt a resolution or other declaration, especially if it's a public agency, if it's a special district that doesn't have the ability per se to declare a local emergency. You don't have to declare that you're complying with the Brown Act because of the pandemic. You just need to provide the information in your agenda and notices. I think here's a good question here, Eric. Do members of the legislative body include alternates? And for a JPA staff or members of the legislative body, to the extent alternates attend the meeting to maintain, especially for a JPA, and Eric, you're a general counsel of a JPA. If they have alternates that attend the meetings so that they stay informed, and then if a member is absent, a regular member is absent, the alternate steps in, they would be members of the legislative body, would they not?
Yeah, that's always been my advice. And I was wondering about what specifically this question related to, but as a general matter and a general principle, I've always considered them to be a part of the legislative body. And this is for other things. For example, when we request a Form 700 for our members of the legislative body. I also include alternates. That's probably conservative, perhaps, but former commissioner on the FPBC like to make sure that we're covering our bases, and so yeah, so that's something that I tend to take a more inclusive approach on that.
What type of reasonable, I think we talked about this, but what type of reasonable accommodations must be provided if no physical location for the meeting is made available? Again, I think you need to consult your IT department or your agenda management company to make sure that the agendas, as they're posted on the website, are in a reader format. What I mean by reader is that they're ADA compliant, so that they can have their program read the agenda items back to them. And I've also seen the opportunity, if you're doing a Zoom meeting, if someone asks for a reasonable accommodation who is hearing impaired, then you may have to have a person who's on the Zoom who's doing live American Sign Language. So there's another opportunity there for a sign language interpreter on the Zoom call, interpreting for those who may require a reasonable accommodation because they're hearing impaired. If there's no reportable action taken in closed session, do you still have to reopen the meeting for public? If you're just doing a special meeting that's just a closed session, and if there's no reportable action, I do believe you still should have an item there if there's no reportable action taken, because you may have members of the public. We know under the Brown Act that reportable actions should be done at the meeting where the closed session was, where the closed session occurred, the same meeting. So you don't want to foreclose unless you're just going to be clear, you're just having a discussion and there's no action that's going to be taken. I don't think you need to have a reopening for the meeting in the public. But if you're not sure, it's always good just to be safe to have an agenda item to reopen the meeting in public session. That's been my advice. Do you have anything else to add to that, Eric?
No, I think that's right, Rich. Always a best practice. It's just maybe a little bit more time, but even to go back into open session just to say there is no reportable action, I think that's best. You know, even if it's not required, that's probably the most transparent way to do it, and I think the public would appreciate that, because otherwise they wouldn't know whether or not, maybe they might think it's forgotten, like we forgot to come back or something like that. I would just put it on the record that there was no reportable action.
Great. Interesting question here, Eric. I think, what's the best practice for recusals when that member is participating remotely? This attendee thinks that announcing the interest, signing off the meeting, and having a staffer call the member once the action on that item is complete is sufficient. Does that make sense? I think it does.
Yeah, that sounds right. They do need to identify their basis for recusal, in the open meeting, so everyone's aware of that. And then, yeah, it could be a staff member sending them an email or a text message letting them know that we're reconvening, or they could rejoin the closed session, or maybe they're just joining back in open session. I think that's appropriate.
And good. And again, I think to reiterate a topic you talked about just a few minutes ago. Do we think it's sufficient to distribute an emailed public comment to a legislative body and simultaneously post them to the city's website, or do the emailed public comments have to be read into the record? I think that it's sufficient to distribute the emailed public comment to the body, and to notify for your clerk to make an announcement that we received public comments. They'll be posted to the city's website as part of the record of the meeting. They are public records that are easily accessible, and we will provide them to anyone who asks. It is my understanding, though, that some city clerks, and I think this is okay, if a member of the public wants their comment, again, during this time of the orders, to be read into the record during the public comment period, some city clerks are doing that and reading them because the requester specifically asked. They're not able to access the meeting. I think that's also okay, but if the requester, if the person making the comment doesn't make a preference, doesn't say, I would like this read into the record, and to me, it's okay to just distribute the emailed public comment to the body and have it posted to the city's website. Do you have any other advice on that, Eric?
Yeah, I think that's correct. And the only other thing I'll throw out there as a practical consideration, if you have council meeting procedures that limit public comment to, let's just say, 3 minutes, and someone submits an email comment that is 5 pages long, that might take 5 minutes or 6 minutes to read, someone will need to make a judgment call regarding when to cut off that time. So you could still comply with require compliance with your meeting procedures. So if there is a limit on the amount of time for public comment, but again, it raises this questions of if the person's reading really slow or maybe they are reading really fast. So, but that's just something to consider. You may have that issue come up, and I think that being consistent. I don't think it would be inappropriate to disallow a 10-page email if someone submits that, but that may be the case. So just want to throw that out there.
Thanks, Eric. I just want to point out it is 1:03. Eric and I are still here, and we'll keep on answering questions until the last question is answered. So if you want to stay on, you're more than welcome to. Just to Stephanie, there's no particular time limit, right? That we're restricted on this, and we can just keep on going. Is that correct?
Yes, that's correct.
Okay. So Eric and I will keep on going. If you have questions, please continue to use the question and answer box, and we appreciate all the questions. Here's a good question. What about for legally required public hearings? The same applies in terms of we don't need to provide a physical location. I think the answer is yes. The Brown Act does contemplate that all the rules related to how you conduct your public meetings should fall under the Brown Act. If that includes public hearings, then public hearings should be conducted in the context of the Brown Act, of a Brown Act public meeting. But how you do your public hearings, your procedure should be followed in the same way. That's how I advise on that. And my particular clients are continuing to hold public hearings in this fashion, and taking public comment during the public hearing portion, reading them into the record, and so forth. Eric, to your point, to your statement, can you have an emergency meeting with less than 24 hours notice?
Yes, you can. You can have an emergency meeting with less than 24 hours notice. And I just wanted to, if I could, Rich, dovetail on the last question regarding in public hearings.
Sure.
One thing that I did want to mention that I think it's just worth considering from a practical standpoint, if you have really controversial items that you would like to bring before your council, and we're now in this space where we're dealing with teleconference meetings and video conference meetings, dealing with, for example, an administrative hearing or proceeding before your council can be very challenging, both from a logistical execution standpoint, but then also from a, guaranteeing and assuring due process for, the applicant or whoever might be before you. So to the extent that you can defer some of those really hot button controversial issues, I think that that's probably wise to the extent that you can. I fully appreciate that that's not always going to be the case, but again, trying to put your agency in the best position to avoid some sort of a challenge to that final decision or outcome. This is still very much a gray area here, even though there is this executive order that provides these protections, there are due process considerations. And so that's just something to keep in mind when you set your agendas and give some thought to the matters that you want to bring forward.
Interesting question regarding the Executive Order N35-20 briefings. Do they include training to officials and on how to use the new platforms? I'm not sure.
Yeah, that's so it's interesting because the language of the order is not that specific. I think it is, relatively broad in that it covers, updates concerning impacts of COVID-19, the government's response. So theoretically, kind of coming to, figuring out how to deal with a video conference system platform could be in part the government's response to this. So there is some language where you could probably fit it in there. And I think it's probably appropriate. I think if you want to have a meeting with your legislative body to essentially test run and dry run a Zoom platform, and as long as you're not discussing anything on there and you're really just providing them with information about how to use the system, I think that would be very much appropriate. And I almost feel like that's expected, given, because that's going to help with the efficiency of the meeting that you actually put on. And again, as long as you're not discussing anything and there's no actions being taken, I think that's probably within the spirit of the order.
So here's a good question from Lynn, and there's a follow-up question to this. Is the public body required to provide a method for members of the public to speak at the meeting in real time And if so, do they have to be allowed to speak after a staff presentation and before the vote? I think the answer, if you're going to have a teleconference meeting, just like we would under a regular Brown Act meeting, if we were not under the orders and you still had a teleconference meeting, you have to provide the public an ability to speak at the meeting in real time. I believe that must comply with the Brown Act. If you're going to have a Brown Act meeting, you still have to have that capability and that ability. I think the platforms do allow for that to occur. It's just a matter of how do you manage it, and having your administrator like this mute participants until it's time for the public comment on the particular agenda item, then they can unmute and provide for an opportunity for members of the public to essentially queue and stand in line. They'll be able to speak next, they'll be notified, and they'll get their time at that particular moment. So they should be able to speak after the staff presentation, I presume, and before action is taken. Again, I think you have to provide, if you're going to have a teleconference/video conference meeting, you have to provide members of the public, they have to be able to participate through the meeting, through the video conference or teleconference, either way. And they have to be able to participate by providing comments. You can control how the comments are submitted, just like you would at a regular meeting by conducting an orderly meeting, through muting them until they're allowed to speak during the public comment portion, or they're allowed to speak during the comment portion on an agenda item or during a public hearing. We had a couple of questions regarding how do you deal with public hearings for a development project? How would an applicant participate in the hearing? Again, I think that depends on the platform that you use. There are ways, I think, again, it will have to be all done electronically, that they, for example, Zoom, you could share screens. So screen sharing by applicants, again, probably administered by staff, would have to be done. So again, your ability to have a public hearing, I don't believe is restricted by the platforms. The platforms allow you to manage the way that the public hearing is done in an orderly fashion. And I think that's required by the Brown Act. And again, if you're holding meetings, again, according to some sort of procedure, whether it's Robert's rules or another one, I think you're allowed under those rules to be able to set the procedure of the meeting so that everyone gets their opportunity to speak. Any questions? Any other comment to that, Eric?
No, I think that covers it. Rich, I see a question here regarding an interpreter, and I really like the suggestion that you offered to me on this one. Any thoughts on how to handle requests for an interpreter for those online/phone meetings? I have not found any of the platforms translate for the user. So one thing that you might consider on a Zoom platform, because you'll have the image of all your legislative body, they'll have their videos visible to whoever attends. You could maybe have an interpreter have their own box, so they would be also on the Zoom conference. They can sign or maybe have some other different way of communicating out and translating. That's one suggestion. I've never seen that done, but that was one thing that Rich and I discussed earlier. So it really depends again on the barrier to access, but that might be one thing you might consider, using a different box on the Zoom platform for interpretation and translation services.
I think we've answered all the questions I've seen here, Eric, in various ways. I don't see any other questions. And we're seeing some chat here about Facebook Live with an interpreter and using Spanish. That's amazing.
Yeah,
I believe that's it. I think we're finished. I want to thank all of you for your participation and for attending this webinar. I believe that Justin and/or Stephanie, our staff, will be sending around a code for MCLE. And again, we appreciate all of your participation. And Eric, do you have anything else to say in closing?
Yeah, I'll just say thank you all for attending and for participating. Our contact information is now up on the slides. We're all dealing with these challenging times the same way that you are, whether it's working from home or trying to navigate the logistics with some of these video conference and teleconference meetings, consider us a resource. Feel free to reach out if you have questions. If you have any follow-up questions to the presentation today, our emails are available here. We're here for you as a resource. We want to support you. We're all in the same community together, and we're going to get through this together. And thank you for your time, and thank you for attending, and I hope you found it helpful.
Thank you.